Welcome everyone to What's Different in California. My name is Anna Manzano Fairbairn. I'm the digital media and event strategist here at the California Employers Association. I have the great pleasure of introducing our trainers today. So we have Astrid Servin, who is delivering the content, as well as Mary Bradford and Eli Nunez, who make up part of our team of amazing HR directors, and they will be managing the Q&A. So all in all, you are in great hands, and I will give it over to Astrid.
Thank you, Anna, and welcome everyone. Welcome to today's webinar, What's Different in California. My name's Astrid. I recognize some names out there, so I may have talked to you in the hotline if you called into our hotline, or you may have talked to Eli or Mary, who also are part of our team here. So we are all excited to share what's different in California, what's not different in California, right? We're actually going to be changing this name to What's Unique in California, because there's a lot of things that make us differentiate us from the other states. And if you're joining me from other states, you know that very well. They call us the Golden State. I don't know if that means ever-changing rules, because that's what we have here. We have to keep up with our labor law updates annually, because as you know, our laws are ever-changing. So new laws come in, and we stay up to date. So hopefully you know us already. We're a California Employers Association. There's a lot of you on that are not members, so we want to spend some time to introduce California Employers Association. We like to pride ourselves by saying we provide peace of mind with exceptional HR compliance solutions, training, and coaching for your teams. And we do this throughout the state of California. We've been all the way to the border of Oregon, all the way to literally the border of, we had a member who is literally on the border of Mexico, down in San Diego County. So we like to provide in-service, so we show up at your location if you'd like us to, and then we also do things remote. So we provide an unlimited phone service if you are a member, where you can call us 8 to 5 Monday through Friday for any kind of HR assistance that you might need. These are quick and responsive answers. You'll get someone like us here at HR Advisors that will answer your calls. A lot of times you HR professionals know what you're doing, you know what to do, but you kind of just need to bounce it off someone. Or you might just want to make sure there isn't something new, because as we know, California keeps us on our toes. So we also, with your membership, provide employment forms, policies. We have fact sheets on a variety of topics, and those are always up to date. So as soon as there's a law that changes, we update our forms, our policies, our fact sheets. So always get them when they're fresh. When something pops up, you'll know to go into our website and download the most latest form. We also have what's called toolkits, and we have toolkits for a variety of topics that are a little bit more tricky. That could be something like a leave of absence, and you're unsure of what leave of absence applies to this specific employee at this specific time, and the leave of absence toolkit guides you through it. It may be a termination, and we have termination toolkits. It may be an ADA situation, which we know those are very tricky. You might be employing a minor. So all those things are in our toolkits, and they provide kind of a fast way, a guide for our members to go through. We also provide training such as this. This is a sample one. We're going to do high level of what's unique in California, but we do all kinds of trainings throughout the state on a variety of topics. We also have a handbook template that we can either help you with, or you can download the handbook template yourself and customize it. So we do workplace investigations, negotiations. So again, a variety of things that are all along the HR world. So what we are not, though, is a law firm. So this presentation should not be relied upon as legal advice. Consult with your own attorney about issues of legal significance. This is the kind of stuff that our lawyers make us say, because we want to make sure that your conversation with your attorney is confidential, it's privileged, and you're doing the right thing by them. So a lot of times we can get you to the place where you need to go now and speak to your attorney. So so we're clear, though, this presentation shouldn't be relied upon as legal advice. All right, so what are we going to cover today? Again, this is a very quick, there's so many things that are different in California that we're going to talk about the most important things, and we're going to highlight them as best we can so that you can then take them and maybe even give us a call if you need additional help with it. We're going to talk about your hiring best practices, everything from the beginning of the relationship, your applicants, onboarding. Then we're going to go into, now that you've hired them, with the wage and hour obligations that an employer has. We're going to dive into leave of absence absences, because there's quite a few unique things that are unique to California, leaves of absences. We want to make sure you get them right. Some of those things have changed even this year, so we're going to talk about that. The end of the relationship, not all employers are going to work for you forever. So we're going to talk about our obligations, because there are some unique things in California when we end the relationship. And then what are our training requirements? Quite a few in California, so we'll talk about those training requirements. A lot of them we forget about, so we're going to remind you about them towards the end of our training. So let's get started here. And like Anna said, please use the Q&A, not the chat, but the Q&A, so that Eli and Mary can answer your questions as we move along. Okay. All right, so let's talk about recruiting and hiring best practices. We want to start off on the right foot. California loves its workers and they protect their workers. And so when you have an orientation, the state wants you to cover compliance information. So you want to make sure you have everything that you're compliant with. And then you also want to inform them of their rights and responsibilities. So they take that opportunity for you to hand them things such as, what are their rights for a leave of absence? What are their rights for crime victims? So lots of different programs, SDI, paid family leave, all these things that we'll talk about here. They take the opportunity when the employee is being hired for you to communicate this with the employee. So we want to make sure we get that right. One of the most important things you want to have is an at-will statement. You want to have this on your offer letters. You want to have this on your handbook. These disclaimers are going to protect you. The at-will statement says that the employment relationship is at will and can be terminated by either party, right? Either the employee or the employer without cause or advance notice. So we want to make sure we have this in writing so we don't risk our managers or supervisors promising someone something to an employee, a definite amount of time where you're guaranteeing an employee. We're not doing that because we have an at will statement. So we want to be consistent in your applications, your offer letters, your handbooks, all this should be, this at will statement should be on there. You want to make sure that you put who has the authority to modify that at-will statement, so that if your supervisor or lead says something they shouldn't, you can point to the at-will statement saying no. Only very senior executive leadership, such as the CEO or the owner, someone at that level is the only one that has authority to change that, and it has to be in writing. So we want to make sure you cover that. So can you just terminate someone using the at-will statement? You can, I suppose you can, but it's not always recommended or the best practices. Employees are going to be left wondering why they were terminated, and that could lead to exposure for the company. So although you have that at-will disclaimer, you want to be careful when using it. You want to make sure employees know the reason why. So we want to document the reasons for performance issues or misconduct issues. You want to make sure that employees who are left are not feeling like, what if that happens to me? Or morale issues can come up. So follow your company policies, communicate professionally with them, and make sure that you're following up with them. But always have this at-will disclaimer. So now we're going on. We're talking to employees. We're asking them to apply at our company. And can we ask for salary information on our applications? Once upon a time we could, but all employers are prohibited from asking or relying on applicants' salary history as a factor in hiring. So we want to make sure we remove those questions about salary from job applications, from interviews. We're training our managers not to ask those questions during the interview process. It doesn't apply to voluntary disclosure. So if someone is voluntarily letting you know what they've earned in the previous position, that's still okay. It's fair game. You can also ask what their salary expectation is. That's still okay. Or what do they desire their salary range to be? That is valid. But you can't specifically ask them what they were earning in their previous position. Employers are required to provide, upon request, the position's pay scale information. So we'll talk about that because that's part of our pay transparency. So in 2023, just 2 years ago, we had this pay scale, pay transparency law come up. So employers can inquire about salary expectations again, but not the history. But you do have an obligation to provide that pay scale to any current employee for their current position upon request. So know that if an employee asks you for that salary history, you're going to provide that. And if you have 15 or more employees, you do have to include that pay scale for a position in any job posting. So and that's 15 or more employees anywhere. So if you have that, you are posting and your job ads, you're putting on there what the pay scale is for that position. And if you go to LinkedIn or if you go to these websites where you're looking, a lot of times they're not doing this and they're out of compliance if they have 15 or more employees. So we want to make sure that we're following this pay transparency law out there. Let's talk about pre-employment guidelines for pre-employment testing, because we have employers that do pre-employment tests and it's still allowed, but you just need to be careful because they are allowed for the most part after a job offer has been made. So if you do these pre-employment tests, know that a conditional job offer has to be made and that you're paying for the cost of all those pre-employment tests. Okay, so if you're drug testing, if you're doing any kind of physical, mental exam, you, the employer, are paying for the cost of those tests pre-employment. And while we're on the topic of drug testing, a lot of you are still doing pre-employment drug testing. Just remember that cannabis use rights now, cannabis is a protected class under FEHA, under Fair Employment Housing Act here in California. So we want to make sure that we test correctly for that. It is only permitted to drug test after that conditional job offer. And then as of January 1 of last year, employers can only test for the presence of the psychoactive metabolites, or the THC, found in cannabis. So we have to be careful because most of our drug testing facilities aren't able to only test for that THC presence, and therefore many employers are choosing just to take cannabis out of the panel completely or using a different kind of test that is the correct test. So you're going to want to call your clinic and make sure that they're either taking cannabis out of the panel or are using the proper test when testing for cannabis. And this is going to be true for pre-employment drug testing. It's also going to be true for any kind of reasonable suspicion testing that you might do. So ensure that that you have cannabis as a protected category and under FEHA, and you're also ensuring that you're not drug testing for this specific thing when you're doing pre-employment drug testing or reasonable suspicion. For physical and mental examinations, these are again permitted after a conditional job offer has been made, and the exam has to be job relevant and consistent with business necessity. This means that you really have to have a reason why you're testing. If this position, you have a reason to believe, okay, there's a physical or mental aptitude you have to reach, then yes, it's valid. But if not, then we shouldn't be doing these. A lot of times this has been a historic thing that a company has done for ages, but there's really no rhyme or reason for the position that we're actually hiring for. Or it may be for a specific department, but not another. So please be careful when you're doing this. There's been lots of companies, including Walmart, who have gotten in trouble with doing pre-employment testing that isn't valid for the position that they're actually hiring for. So be careful with that. Let's move on to the Fair Chance Act, because this is something we want to make sure we cover, that you're aware of. There's been some changes to, if you have employees in LA County and San Diego County, some new ordinances that went into effect at the end of last year that you should be aware of. So if you have employees in the unincorporated areas of San Diego and LA County, you're going to want to look a little bit further because this is the state version here. So the state, this is for all employers, you cannot inquire about criminal history if you have 5 or more employees working for you during the interview process. It can be done and after a conditional job offer has been done. So again, train your supervisors on this. We're not asking them about criminal conviction history. We're not running background checks until after a conditional job offer has been extended to the employee. And then even then, you're going to find something might pop up, and in that background check or in the interview process where they're telling you about this, you can't deny that job unless you're able to show that that conviction has a direct and adverse relationship with the specific duties of the job. And they really do need to be specific duties of the job. So again, we're using caution when doing these background checks. We're looking very deeply and closely to when the conviction was it from 10 years ago? Was it very recent? I mean, how does that relate to the position that I'm hiring them for? We always use the example of, I have delivery drivers and there's a DUI in the record from, 24 months ago. Okay, there's a direct and adverse relationship to that job duty. But if they're a receptionist that has no driving abilities, that may not have a direct and adverse relationship. So you really need to look at things on a case-by-case basis. You need to ask those questions. You need to do an assessment. California does require that. So we'll go a little bit more deeper in this. If you are going to rescind that offer, you've made the decision, you've looked at it, you feel that there's a direct and adverse relationship to that position, and so we're going to rescind the offer. You have to provide written notification of that preliminary decision. You have to say what conviction was the basis for your decision specifically, and you need to provide them a copy of this conviction history report, and then explain to them that they have a right to respond to your notice within 5 days. So all this is through our Civil Rights Department. FEHA protects this, and Civil Rights Department actually has some of these forms that you can use. You can go to our website at employers.org and find this. You can also go to the Civil Rights Department. They will require you to have an adverse action notice to give to the applicant if you're going to deny that. So you wait the 5 days. You wait for them to say, look, this is not me, this was an error, this was from 10 years ago, this is what happened. And you have to listen to their story and see if there's anything there that might change your mind. And if you still deny that employment, then provide that final letter that you can find. It's called an adverse action notice. So just know there's quite a few different steps that you need to do if this is going to be, you're going to be denying or rescinding an offer due to criminal conviction. It's very important you follow these steps. Easy way for an employer to get into trouble and get a charge filed against them. We have background specialists there, so there's a bit.ly there that's provided for you if you'd like to look at our safety partners that provide some background check on this specifically if you are in trouble or if you need a little bit more assistance in this area. And just remember again, San Diego, LA County, they have a few other ordinances that require them to be a little bit more hands-on with that. Let's move on. Now we've found our candidate, we've passed the background check, we've asked the right questions during the application, we love this applicant and we're hiring them. So now we get into that orientation where we give them a bunch of forms, right? We're giving them quite a few forms that it's daunting. And so we want to make sure that someone is there explaining what these forms are, that we're not just handing them a stack of papers, that we're checking again. We're not going to read all these required hiring forms, but we do have them here for you to review. I do want to highlight second to the last form on this screen, which is the Crime Victims Notice. As you may know, there's been some changes to our Crime Victims Notice effective this year in 2025. What year am I in? If you need more assistance in, by the way, the labor laws of 2025, we do have labor law updates that you can register for. The Crime Victims Notice, we've always provided employees what our policy is. It's in our handbook, but there's actually a specific notice that's going to be provided by the Civil Rights Department this year. They are going to provide it by July 2025. So the new law and all that is involved in this new law does need to be provided that notice. However, we have until the Civil Rights Department publishes that. So if you stay connected to us, we're sort of nerds about that kind of stuff. We like to stay on top of the Civil Rights Department and when they publish things. So if you follow our blog, which is free, we will publish that and we will alert. If you're a member, we will let you know, members, when the Civil Rights Department publishes that Crime Victims Notice, and that way you know that's your responsibility to start using that notice. So there's more. There's page 2 here of the required forms that we have to give our employees. And again, some of this is compliance, I-9, W-4, the California state forms, and some of it is informational. We're giving employees information at the time of hire so that they know either now or later they're going to be eligible possibly for certain leaves, because life happens and then they may need certain protections while they're employed with you. This is the time that you're giving them. So to be in compliance with our hiring laws, we need to ensure we're informing them of all these laws, all these protections that they have. So there's quite a few more. Just want to highlight that last one too. If you have sales employees in California, it is required that they have a written commission agreement. So make sure that is part of your hiring packet, your onboarding. If you have salespeople, they do need to have a written commission agreement on there. All right, so when we talk about labor law, wage and hour laws, they apply to our employees. So we want to, before we get into the area in the slides of wage and hour, we want to make sure that you know what's the difference between an employee and a non-employee. So the definition in California of an employee is anyone who performs services for the benefit of an employer. This is going to include minors and undocumented workers. And it's not going to include independent contractors and interns. That's separate. They're not part of that, the wage and hour responsibilities that we have. But let's talk about our independent contractors very quickly. We are not going to talk too much about them because our presentation is for your workers, for your employees. But just know that if you hire independent contractors, California is very different when it comes to independent contractors than federal law. Federal law is catching up, I think, to California, but we have to follow California law here. So if you hire an independent contractor, for the most part, they need to follow what's called an ABC test. Because in California, workers are presumed to be employees unless they can satisfy this ABC test. And the ABC is A, that they're free from control and direction of the hirer. So they're kind of an independent person who's they have their specialty. They're going to perform work that is outside the usual course of the hiring entity's business. So they're not doing what you do. They're bringing something unique into you that you don't do. Maybe you are a painting company and you need a graphic artist to do something for you. That's outside the usual course. But if you're just kind of have a maybe heavier workload this month and you need extra painters, you can't hire them as independent contractors because that's what you do. That's your business. And so you need to, even if it's for a month that you need them for, you're going to have to hire them as employees. And then C is customarily, the independent contractor is customarily engaged in a trade, occupation, or business of the same nature as the work performed, which is kind of what I was saying. So make sure that they're also doing this type of work for other businesses. So they're not doing it just independently for you, but they're a graphic artist that does this for multiple employers, not just you. So the penalties are pretty steep. They went very high. So we want to make sure you know that when you're hiring a worker, that they are properly classified. Always assume they're an employee unless they pass this. There's a lot of exceptions because we even had law elections that we voted on. We have the Uber and all these that we have a lot of exceptions. So make sure that you delve a little bit deeper. If you're a member, give us a call and we can talk to you about those exceptions. There's also a new law in 2025 for freelance workers too. So make sure that if you have freelance workers who are independent contractors, there's further obligations about that as well this year. Okay, so now we've established we have our independent contractors. We're not going to talk about them anymore. They're W-9s. They are their own people. But now we have employees that we need to really focus on. So we're going to go into the pay and benefits and wage and hours section of our presentation where we're really talking about our pay because we do need to pay our employees, right? Apparently they're not going to work for free. So we got to do something here to pay them. Well, California has a minimum wage that is much higher federally than most federal. And by the way, we have a lot of ordinances, cities and counties, and we'll talk about that in the next slide, but we have that too. So you just got to be aware. The California one, we used to have, depending on the employer size, we had a salary that went along with it. No more. At this point, all employers, no matter if you have one employee or many, we all follow this California rule. For minimum wage, it is $16.50 an hour. And for our salary folks who are exempt, when we have an exempt employee exempt from wage and hour laws, we have to pay a minimum that is double the state minimum wage. So that rate right now is sitting at $68,640, which is quite high. If you've been paying the minimum, then every year this has been going up quite a bit. And because of that, you may need to reconsider, can we afford to continue doing this, especially as we go on into 2026 and we continue to increase the minimum wage. Your exempt salary folks need to increase their exempt salary as well. So you may be asking, is this the time that I should maybe drop them to a non-exempt status? They've always been exempt, but now I just can't continue paying this minimum exempt salary, so I'm going to switch them to hourly. Well, you can do that. Just remember that there's quite a few things that go along with that. This exempt employee now needs to track their time card, their meal periods, their breaks. So we do have a little tip sheet here, a transitioning exempt to non-exempt, some employee relations issues that go along with that as well. So if it's helpful, it is free for all employers. We have this bit.ly there that you can follow for some tips on that. And just remember, this might not hit your radar now, but in future years, it may be something to consider. All right. And then, like I said before, we have quite a few local minimum wages. So depending on where your employee works, that's where we're paying. So this is going to be a factor. So if your employee is working in a certain ordinance or has moved to a different place, and that's where they're performing work, maybe they're a remote worker, or maybe they're a driver that goes into the city for training, you do need to follow those laws. If they spend, typically it's more than 2 hours in that city, then they need to be paid that by that ordinance. But check the ordinance to see what the rule is, because again, their minimum wage will likely be higher, and with that usually is sick leave is higher as well. So you're going to want to look at both minimum wage and sick leave for the locations of where your employees are working. Physically working, and we do have that as well for everyone, that state and local minimum wage bit.ly as well, so that you can follow what the current minimum wage is. And again, we update those all the time. Typically we see a mid-year increase for these local ordinances, so stay tuned with us, because in July we'll have a mid-year labor law update, and we'll also update this form, because at mid-year tends to be when our local ordinances, our local cities and counties change the minimum wage for them as well. They don't usually do it at the beginning of the year, they usually do it at the mid-year mark. So just stay tuned, be aware. There's also predictive scheduling, some flex time if you have employees in San Francisco and the Bay Area that you need to be aware of, and that in LA County as well has some of those predictive scheduling. That's becoming more popular. We probably will see that trickling down to the state level in a few years, I anticipate, but I don't know for sure. But usually what the Bay Area does, that kind of sets the stage for what the state will do in future years. So just be aware of this, that there are other minimum wages out there. By the way, if you have an exempt employee, the exempt employee salary is dictated by the state minimum wage. So even if your salary employee is in San Francisco, for example, where the minimum wage is higher, your obligation is to follow the minimum wage for state. There are exceptions, of course, to restaurant, to rent industry, a few other industries that have higher minimum wages as well. So just be aware of industry minimum wage as well. Okay, so let's talk a little bit about overtime, how we pay our employees. Overtime in California has to be paid at time and a half the regular rate of pay, not the base rate, but the regular rate. And we'll talk a little bit about what regular rate is in a minute. We're going to pay overtime for all hours over 8 in a work day. Over 40 in a work week, and how you define the workday and the work week matters. There's a default in California of what the workday is and the work week is, but you as an employer can change that into any kind of 7 consecutive days and any 24-hour period. You just need to notify your employees of that verbally and in your handbook so that you follow that. And it matters if you have employees working possibly overnight, different shifts, maybe 7 days in a row. It's going to matter when overtime hits for those employees. So it may make sense for your workday and your work week to be different than what the state has as their default. So you're also going to have overtime for the first 8 hours worked on the 7th consecutive day in a work week. Again, you have to be careful where that 7-day lands, if it's actually in your work week or in 2 separate work weeks. And then you have to pay double time or 2 times that regular rate for anything over 12 hours in a work day. And then if you are working on that 7th consecutive day, it's going to be overtime. But then after that 8 hours, hopefully you're not working that much, then it triggers that double time. Okay, let's keep going to that regular rate that I mentioned before. It's different. Don't confuse it with your base hourly rate. An employee's base hourly rate is what they get paid for every hour that they work, but the regular rate includes a number of different earnings. Things like commissions, piece rate, shift differentials, non-discretionary bonuses, any kind of 2 different types of rates of pay that your employee has is going to be factored into the regular rate. And that matters because we use that regular rate for for overtime. We also use it for premium pay, which we'll talk about in a minute. So some meal and rest break deal breakers. This is when employers may get into hot water and have penalties or fines that are assigned to them because they fail to do these things. And these are pretty common, so we thought we'd mention them. Failing to relieve employees of all duties or relinquish control during their breaks and lunches, not giving a reasonable opportunity to take them, such as you're not scheduling enough people so employees aren't able to take their break or their lunch or maybe someone called in sick and they can't do it. So again, you have to remedy that. Coercing, impeding, or discouraging employees from taking their meal or rest breaks, not keeping track of it. Remember, California requires employees to have a time card, an hourly employee to have a time card, and the meal period has to be tracked. That meal period is unpaid, you're clocking in and out for it, and you're showing proof because we have to see that you took that meal period by that 5th hour, which we'll talk about next, but that needs to be tracked. Also, rest periods are paid. They're on your clock, employer. So they're not clocking in and out for that. Some employers clock in and out just for tracking purposes, but be careful because we want to make sure that it's consistent and that you're actually paying them for that. So when they're clocking in and out, it actually is just a way to record it, but not taking away from the employee's pay. So some more into meal and rest breaks. So let's talk about rest breaks because the Department of Labor Standard Enforcement says that employers must relieve their employees of all duties and relinquish any control, meaning you can't dictate where they go. So remove from your policy or your handbook that employees have to remain on the premises while they're on break, because even though you're paying for that break, you do have to relinquish any control over how they spend their break time. So we want to make sure that we're authorizing, permitting, and allowing them to run to Starbucks and back if they can do it within 10 minutes, okay? It should be in the middle of each work period. You're seeing a chart here of how many rest breaks, depending on how many hours they work, is what they're allowed to. The penalty to provide this rest break is 1 hour of premium pay, what we call it premium pay. And that 1 hour premium pay is just 1 hour of time at that regular rate of pay. It's going to be the same for meal breaks. So a meal break, you have to provide a minimum of 30 minutes of a meal break. You have to show that, track it. If an employee works more than 5 hours in a day, you can waive that meal period if you're working up to 6 hours total. But if you go over 6 hours and 1 minute, you do have an obligation to provide that 30-minute meal break. The timing of it, again, has to be by that 5th hour. So an hourly employee has to take that meal period by that 5th hour. So we're talking 4 hours and 59 minutes into the shift. Employers sometimes have to be very creative on how they schedule these. You might have to say, look, we don't want you to go and clock out at 4:59 if we have a long line of employees trying to clock out. So let's have everybody maybe stagger those meal breaks or start breaking at 4 hours or at 4.5 hours so that we're not at that 4 hours and 59 minutes because if we go over that 5 hours, we now owe them that premium pay because that failure to provide is 1 hour premium pay. Failure to relieve of all job duties. If we're asking an employee to come right back to your desk and do this really quick, can you send out that email or take that call? Now we owe them that premium pay. Okay, so that's 1 hour of regular rate. Here's an example of an accurate wage statement. Quite a few things on there, so just take note of it. I know you're getting copies of the slide. One thing I want to just put on your radar is this premium pay that we've been talking about, because those are wages, so we do need to have a separate line item for them on that wage statement. If we fail to, again, provide that, maybe they were traveling and they were unable to take a break, we're paying them for that break, for that meal period, and we're putting them on that wage statement. It protects you, employer, because you're showing that you paid them that. They can't come back and say, I never got paid, you're in violation. We're showing that, yes, we know we were in violation and we're correcting it by paying you that premium pay. So that does need to show on that wage statement, among other things, such as paid sick leave, also has to be on that wage statement. All right. Want to just touch on this briefly because there are some really good PAGA reforms that have happened this year in 2025. PAGA is the Private Attorney General Act, and if you've ever been involved with one, I'm sorry, because I know they're not pretty. I know they are cumbersome and stressful, but now we have a new opportunity for employers to reduce those penalties, which we all know are super high, if you can demonstrate that you took reasonable steps to comply with wage and hour laws. And let me tell you, it's quite a bit of a difference, really quite a bit of a difference. So this new opportunities to cure following a PAGA notice, you're going to want to consult with legal counsel on how you cure it, because if you find all the stuff we just talked about with breaks and lunches and you're suddenly going, oh no, I'm in violation, I don't know what to do to correct it, well, you're in luck, because this year PAGA reform is really going to set you possibly those penalties quite lower, but you do need to do your part. So we do have a wage and hour training that happens to be coming up in February 26th. It's going to include a certificate of completion, which again, because these reasonable steps, one of the things you need to do is do an audit. You need to do payroll audits and take action if you see that something was done wrong. You need to have policies on there. You need to train your supervisors. That's part of the reform if you do this, and take corrective action when you find that people are not following the rules. Your supervisors maybe aren't telling you that the employee went to lunch late and you didn't do it. You're taking corrective action when supervisors aren't following your policies. So there's quite a few reasonable steps for employers to do. And if you do these things, then what this PAGA reform is saying is that you have a reasonable way to have lower fees. So we do have a training coming up, like I said, February 26th, if you want to enroll in that. And if you can't make it that day or you want to do it on your own time, we do offer an audit package that's available at our store as well. So you can go through the whole entire, we have audit lists, we have all the templates that you need, and we even include a video for your supervisor. It's like a quick 15-minute video that you just show your supervisors. And again, all this is working towards the reasonable steps that you need to do to comply. That's one way. We still want you to consult with counsel when these issues happen, because there's a lot of layers that you need to unfold. Okay, let's go, because I know we're kind of running out of time here. We still have a lot to cover. And thank you, Mary and Eli. I know you guys are active there in the Q&A. Keep those questions coming. And if you're a member, feel free to give us a call. So CalSavers is something that's unique to California. This is for California employers who do not offer a retirement plan. So California has their own little retirement plan called CalSavers. And employees can opt in and out, but the requirement for the employer is to register. This is for employers who do not offer retirement plans. So if you are one of those employers, you do need to register with the state. They had been given us timelines every year for depending on your employer size, but the deadline for one or more employee is this year, end of this year. So you want to make sure that you're on there, you're registering it there. And what it is again, the employer is providing the information to the state, and the state is then, and by that I mean you're providing them the information, you're giving them the employee's name and information. And if the employee opts in, the employer has really nothing to do other than they're the middleman. If the employer and the employee opts into this program, then the employer submits payroll, submits contributions via payroll deductions to the state so that they can manage this for the employee. So just know that this is out there. If you're an employer that doesn't offer retirement, you do have a responsibility to register with CalSavers and at least get that CalSavers gets that information to your employees. Okay. Out of the wage and hour land, and we're going to dive into the leave laws and time off. So, you know, real world life happens, and there's protections for your employees, no matter where they're at in the stages. It could be from day one and moving on. So let's talk about those protections. And again, very high level. We actually do a whole 90-minute presentation on leave laws because they are complicated and they are cumbersome. There's a lot of details to them. So I'm going to do a very high level overview. If you need more, please contact us and we'll try and get you some help here. But each leave law works differently. Whenever we get a call into a leave law situation, we're going to ask a lot of questions. You know, what's your employer size? How many employees do you have? How long has that employee worked for you? And then these leave laws can run concurrently with other leave laws, and some run separate. So just know that it's going to be unique depending on the situation that you have. First leave law we're going to talk about is paid sick leave. Paid sick leave in California is under the Healthy Workplaces, Healthy Families Act. And we do need to allow 40 hours or 5 days of time off for employees. Excuse me one second. Oh, my apologies. Okay, to address their own serious health condition or that of their family. So this provides them 5 days or 40 hours of job protection. You can run it a couple of different ways. You can give them a lump sum of the 40 hours or do an accrual method. And sick leave is not paid out at termination. Okay, then we have pregnancy disability leave. This is for employers with 5 or more employees. You have to provide a pregnant employee up to 4 months. Now I say up to 4 months because they do need to be disabled by pregnancy in order to be eligible. So the majority of pregnant women are probably not going to go through the entire 4 months. It's really only while they're disabled or while they're affected by pregnancy. So if they're affected by pregnancy and a condition exists, they're likely going to qualify. This includes morning sickness, pre-appointments, things that happen before they even give birth. They're going to be eligible as of the date of hire. So day 1, they are eligible for this protection in California. And this runs concurrently with FMLA, but it's not going to run concurrently with our California leave, the California Family Rights Act. It does state that you have to provide reasonable accommodation for any pregnancy-related health issue. So again, lots of things go into this, everything from, again, pregnancy things such as morning sickness, anything from recovery from childbirth and even postpartum depression. So that you can see how this can be something that is done before, during, and after a pregnancy. So just be aware of how and when it is triggered. And just the most important thing is it doesn't run concurrently with CFRA. CFRA is our California Family Rights Act for employers with 5 or more employees. It provides 12 weeks of unpaid leave, and it also guarantees reinstatement at the end of that leave. Benefits, as you as the employer have to continue any medical, dental, any kind of benefits that you paid for them, these need to remain during that protected time. And the 12 weeks are within a specified 12-month period for eligible employees. They do need to be with you for at least that 12 months and then have worked with you for 1,250 hours in that 12-month period that you designate. And again, run separately from the PDL, the pregnancy disability leave. This is for employees, for their family member, or a designated person. Okay, you have to have a policy on that, a poster, and those mandatory forms for this law. These are the reasons that you can take CFRA. You can take it for baby bonding, for your own serious health condition, family and armed forces, or for family care. And that baby bonding, just as a reminder, an employee can be out on pregnancy disability leave, and that more than likely turns into a baby bonding situation once that PDL runs out and they're no longer disabled. They're ready to return to work, but maybe they want to stay out to baby bond. And that's when this CFRA kicks in for that 12 weeks. Okay, and what are we going to do next? We're going to pay our employees, or well, we're not going to pay them, the state's going to pay them. So while they're on their CFRA, while they're on their PDL, while they're out because of a condition, whether that be their own or that of a family member, the state has a plan, a wage replacement plan called paid family leave, which we think is just the most absurd name because it's not a leave, it's a wage replacement. So paid family leave is really paid family wage replacement. There's no waiting period for an employee. This is how the employee gets paid. Employer, you're not responsible for this. We're just giving this as information. The employee is responsible for applying for this. Your responsibility is to give them that pamphlet at new hire, which is one of the forms that we talked about earlier. So this money is available to the employee. It provides 8 weeks of time off in a 12-month period. So remember, sometimes an employee is taking a full 12 weeks because they're covered under CFRA and they're getting paid by the state for 8 weeks. This is, again, not a protected leave. So if an employee is not eligible for CFRA or for any kind of leave, but they know they have this wage replacement out there and they want to take time off, there's no job protection. So you can either say no, or you can look at the factors and see. You know, there's always a situation, maybe you have a personal leave of absence at your company that you can consider. State disability insurance is very similar. This is state disability insurance is for their own health condition. There is a 7-day waiting period. So if they need surgery, break a leg, and they have, again, wage replacement by the state. Okay. There's lactation accommodations that we need to do, that we need to provide a reasonable amount of break time and a location other than the bathroom. It has to be a safe, clean, and free from hazardous material. They have to have access or a surface for their breast pump, personal items. It has to have electricity for them to be able to use a device. So extension cords, all that kind of stuff is what you need to do to make those reasonable efforts to comply with the law, because there is a violation for that as well. There is an undue hardship exception, no matter what size employer. Please look into that a little bit further, because for the most part, all employers need to comply with this. Let's talk about bereavement leave. There's another leave for employers with 5 or more employees. You do have to provide eligible employees up to 5 days of unpaid bereavement leave upon death of a covered family member. Eligible employees are going to have worked with you for 30 days before the leave starts. Employees have to use the leave within 3 months of the date of death, and they're not required to use this time consecutively, so it can be done intermittently. Maybe they use 2 days for mourning, and maybe they use 3 days to take care of estate planning or other kinds of issues that they might have, so they don't have to be consecutive. Documentation you can require, and again, put it in your policy if you're going to do that and be consistent. You can require appropriate documentation. Now, this is an unpaid leave. You as the employer can choose to pay it. You can choose to pay a portion of it. Some employers do, very common, 3 days out of the 5. So you can just be very specific and be detailed in your policy about what you're going to pay or not pay. What the important thing to remember with bereavement is you do also have to allow them to use any kind of sick or vacation for it. Reproductive loss leave, very similar to the bereavement leave. You have to, this is for employers with 5 or more employees. You do need to provide also 5 days of bereavement leave for each reproductive loss event. And it's each reproductive loss event, so it could be more than one depending on the situation. There's many covered reasons such as miscarriages, loss of events, stillbirth. So lots of reasons why they can take the reproductive loss event. You want to look at that definition. You do need to be employed similar to bereavement for 30 days. You can limit to 20 days in a 12-month period. And again, you're going to want to look at the definition for that. Failed adoption, miscarriage, stillbirth. There's quite a few things that are associated with that. There's a confidentiality protection on there. Of course, these are very sensitive topics. So both with bereavement and reproductive, we have that confidentiality protection. And then there are some limitations on documentation. We can't really request a lot of certifying documentation with this. If an employee makes that statement, we need to allow it. So this is different than bereavement, where we can ask for that substantiation. If the employee, with this one, we cannot request certifying documentation of that loss. Okay, and our last leave that we'll talk about is vacation. Because vacation is very different in California than in most states. You don't have to have vacation in California. There's the employer's discretion whether you do have it or not. You do need to allow for a reasonable cap, because if you do choose to have vacation, then California says there's lots of rules if you're going to have a vacation plan. And one of those rules is a reasonable cap. Cap has to be at least 1.5 times or 2 times what the employee is earning. You can require the use of vacation. So if you want to have a policy that says you must use it by the end of the year, you can do that, but you have to force them to use it. And if you cannot have a use it or lose it, meaning if they don't use it by the end of the year and that's your policy, then you have to pay it out. So either roll it over or pay it out. That's where vacation might be a little bit different than other states. Vacation is always paid out at termination. So and again, vacation is considered wages in California, so we can never lose it. Whatever we've earned, we have, and that's ours. And so if an employee terminates, that has to get paid out. A very common policy out there is that you don't earn vacation until you've been with us for a year, and then at a year you have 40 hours. Well, California recognizes that as you've been earning 40 hours towards that year. So once you reach the year, you magically have 40 hours. That means you've been earning it all along. And if an employee was to terminate, let's say at 6 months, they've probably earned about 20 hours of vacation, and that should be paid out. So all these things are things to be mindful of. You want to make sure you're clear on your policy and that you're paying them out at termination. Personal days, floating holidays, those are just fancy ways of saying vacation in California, because California recognizes them as wages as well. So if you have a floating day, if you have a personal day, an employee doesn't take it, we're paying it out at termination because they are due that, since they are wages and they didn't use them. Okay. Let's talk about ending the employee relationship. Not everyone's going to work for you forever, so there are a few things. Luckily, it's much less than when we hire. Termination meetings are typically very short and simple and to the point. How do we pay? We pay depending on the circumstances. So if you're involuntarily terminating someone, saying the words "you're fired," you're paying them on that last day, and you're handing them the check at the time those words are leaving your mouth. And if it's a voluntary quit with more than 72 hours, I'm voluntary quitting and I'm giving you 72 hours notice, then you've been put on notice and you have to pay me on my last day. If you voluntarily quit with less than 72 hours notice, then we get 72 hours to pay you. So those are the rules for final pay in California. We don't want you to mail a paycheck unless the employee requests that and they put it in writing and provides a current mailing address. The date of that mailing in that case is considered the date of paycheck. So those paychecks, by the way, have to be live or manual checks. If an employee wants a direct deposit of their final check, you do need to have a separate direct deposit authorization that is specific for final pay. If you're a member, we have that form in our HR forms. Okay. A few more things here. Final pay is at the employee's primary work location, not yours. So if they're a remote employee, we're having that check mailed to them. We're having them open that package at the time we're having that meeting. What to include in final pay is all wages owed, including all final pay, because failure to do that opens you up to liability of penalties, which are called waiting time penalties. And those waiting time penalties can add up very high. Special rules for expense reports and commissions, those can be paid at a later date, but only if you're not able to calculate them by that final day. So if you have an employee who hasn't quite earned that sales commission yet at the time of termination and we cannot calculate it, that's okay. That's an exception. Or same thing with expense reports. We didn't know, we didn't have them, and so we paid them later. But if you're able to calculate commission, if you're able to calculate expense reports, we're paying them on that final pay. Here's a look at some penalties. Like I said, they're pretty steep and high. So take a look at those so that you're aware of how high those can be and you get the final pay correctly. The termination paperwork that we're going to give employees are listed here. Very few forms, and mainly that notice to employee, that change of relationship form. All these can be found on our website, by the way. If they're involuntarily getting terminated, you're giving them for your benefit. There's some health notices as well that the state requires. This is HIP notice is separate from COBRA, and then of course COBRA if you have benefits. Some final notes here are the California required trainings. We are going to cover that because sometimes we forget those. The California required trainings are the Workplace Violence Prevention Plan. We don't want you to forget about that. That was implemented in July of last year. It's going to require an annual training of your employees and a written plan. Harassment prevention training is for employees and supervisors. We're doing that every 2 years. There's also mandated reporter training if you employ minors, and there's a heated illness or outdoor that requires training and written plan. We'll go through these really quick because I know I'm running out of time. But the Workplace Violence Prevention Plan has limited exceptions. Almost all employers are required to have this written plan now. There's a template that's provided by Cal OSHA. We also have a toolkit, and we also have training material that you can purchase at our store if you're not a member. If you're a member, you're welcome to download our toolkit on this. We also have videos that go along with this as well. Our mandatory harassment training, again, FEHA requires employers with 5 5 or more employees to cover this. Every 2 years, employees are doing the 1 hour, supervisors are doing the 2-hour version. This has to occur within 6 months of date of hire or promotion. It does need to be an interactive. We used to be able to pop a video and just let it slide, let it go. Can't do that anymore. It has to be interactive. So it can be online. We come on site. We do webinars. There's actually some coming up that you can have employees log into and have a live trainer in this forum. We also have our Zywave, our CEA University, where you can do the online modules, but those online modules are interactive, so different than just a video play. So some key requirements to our workplace violence prevention plan: create and maintain a written plan. You're going to solicit information. There's lots of things involved with the workplace violence prevention plan. We want to make sure you get it right. So again, log in, do the Cal OSHA template, and just ensure that you hit all those markers, especially that training requirement every year. If you employ minors, just know the laws changed in 2021, where now your HR folks and your supervisors over minors are now considered mandated reporters. So know that there's a special training for that, and you can also find that in our store. Cal OSHA requires both heat and heat illness for both indoor and outdoor for all employers. So if you have if you're an employer where the heat goes up to 82 or higher, you're gonna need to have a written plan and train your employees on that. Same thing applies for outdoor as well. So all these things, there's a website there where you can get more tips and tools. You could also log into our website. We actually have a blog about the indoor heat illness that has a lot of requirements and what you need to do, what your responsibility is to provide for that as well. So that's a lot, fast and furious. I just have a couple minutes left, but just want to wrap it up here. As you can see, California remains very unique, and we love our California state, but it does require us to be in compliance. So make sure you get it right. You review your onboarding practices, your paperwork, your wage and hour. Stay tuned with that PAGA reform, which is a big win for employers. Review your policies on leave of absence, terminations, and benefits. Schedule those required trainings. Get them on the calendar already so that you are aware of them. Join us for our upcoming webinar if you need training for your supervisors on LEAD. We call it our LEAD program, which is a supervisor training, and they get certification for that. And then there's also HR 101 if you're kind of new to HR and you want an HR 101 series. These are both all certificated ones. They're 4 to 6 week trainings that we do online for you.
We do really encourage you to share your feedback with us. This is how we continually improve and make sure that we are serving you and bringing you the most peace of mind, which is our entire mission here at CEA. So we do have a quick link to our Google review page. You can either enter the bit.ly or you can scan that QR code. You can choose your own adventure today. We do want to thank you all for your time and your engagement and all of your really thoughtful questions. This is part of what is really so great about being a CEA member is you have access to not just the 3 of these trainers, Astrid, Eli, and Mary, who are, are some of our amazing HR directors, but we have an entire team ready every day from 8 a.m. to 5 p.m. Monday through Friday, ready to answer your questions, and that's unlimited. So we would really love to have the chance to work with you and help serve you more. Thank you, Astrid, Eli, and Mary, for all of your dedication today, and we'll see you all soon. Cheers.